I want to welcome you to our third panel this morning. And of course now it's noon, and we've worked our way from a discussion about the Bill of Rights to James Madison to a focus on the First Amendment. By way of reminder, I am Mike Gerhardt, the scholar in residence here at the National Constitution Center. It's always a great honor for me to be able to be a part of any program here. And I really appreciate your interest and willingness to join us today as we look at the First Amendment. I'm going to give a brief introduction to each of our wonderful panelists, and then I want to sort of begin our discussion, our closer, more in-depth look at the First Amendment. On my far left, which would be your right, Jameel Jaffer, director of the Knight First Amendment Institute. To his right, Jeffrey Herbst, former president of the Newseum. And of course, to my immediate left, Anita Bernstein, professor of law at Brooklyn Law School. We are going to, of course, look at the First Amendment. And at the outset, you should know a few things. Of course, you should know that it didn't start out that way. The First Amendment was not literally the First Amendment that was considered. We've had that lesson driven into us all day. And yet here we are in the third panel, treating it like it's something special. And so a good place to begin, I'm going to start with Jameel, is why is the First Amendment important, and what especially about it today do you think is an important thing to be focusing on?
All right, well, first, thanks for inviting me. So I think that free speech is probably important and felt as important to most democratic societies. I grew up in Canada, and I think Canadians think of themselves as committed to free speech principles, and I'm sure that's true of most European countries as well. But I think that Americans think of free speech and the First Amendment as central to their identity, and our jurisprudence reflects that in a way. The First Amendment is everywhere in American law. There are very few issues that the First Amendment doesn't touch. And one of the most important questions right now is whether that's a good thing or not. There is a school of thought that believes that free speech is best protected if the First Amendment is construed as broadly as possible. And there are good arguments for that theory, but there are others who believe that the First Amendment is meant to reflect certain values. The First Amendment is there to protect, to ensure that the processes of self-government and democratic deliberation work properly, and the First Amendment should protect at least chiefly expression that is connected in some way to the process of self-government. And that's a very important fault line in First Amendment scholarship right now. It's a fault line in First Amendment jurisprudence. A lot of the cases that come before the court right now are cases about what the First Amendment should reach. What kinds of things count as speech, or what kinds of actors count as speakers. So those are very important questions right now, which I will not try to answer. But the second part of your question, what's especially important in this sphere right now, the questions that I spend a lot of time thinking about have to do with free speech in the digital age, the way that new technology has changed the way we communicate with one another, changed the way we communicate with the government, with government officials. And right now, I think one of the most important questions is how free speech ought to work on social media. The social media platforms are private actors, and so the First Amendment doesn't apply to them directly. But those spaces, those social media platforms, are probably the most important venues right now for political speech and speech of many other kinds as well, but especially political speech, including speech about and to government officials. And I don't think we have figured out yet what we want social media platforms to do, how we want them to police those spaces. Should they think of themselves as applying First Amendment principles, even if the First Amendment doesn't directly bind them? Or do we want them to make viewpoint decisions, for example, by taking down accounts that are associated with neo-Nazis? And I think that's a very important question that will have dramatic implications for the vitality and even integrity of political debate over the next 10 or 20 years.
Okay, thank you. And as Jameel points out, I, of course, as a law professor, had to ask a two-part question. It just comes with the territory. So, Jeff, I'll ask the same two-part question to you. Why is the First Amendment important? And particularly today, what First Amendment issues do you think are of special concern or ought to be of special concern to us?
Well, of course, great day to discuss the Bill of Rights and the First Amendment, 226th anniversary of the ratification of the Bill of Rights.
That's a good thing, by the way.
So happy birthday, Bill of Rights. Look, on the one hand, very few Americans can name all 5 freedoms in the First Amendment. Of course, all of you can. But it's in the ether of American democracy that speech, press, religion, petition, and assembly are protected. And Americans know that in a more fundamental way. To me, the importance of the First Amendment and why it's always central to our discussion begins with the first phrase: Congress shall make no law. And that absolutist commitment to freedom, even though it's been modified by jurisprudence and there are exceptions, I think it's the starting point of American democracy in a lot of ways, that Congress shall make no law. And it says that the American perspective on freedom is a profound one. So I think that sets the tone, if you like, for many of our democratic discussions. Then there's the sheer scope of the First Amendment, mentioning the only industry, by the way, that's discussed in the Constitution and the amendments: press, speech, religion, a whole sphere of public and private life, as well as petition and assembly, 2 of the more profound ways which governments are kept accountable. So the sheer width of it and the sheer scope of so many discussions that fall under the First Amendment makes it in many ways unique. So I think it really is foundational to so many of our discussions, not only in substance, but as I said, in tone. In terms of the issues today, because it is such an absolutist statement, underneath the First Amendment, while there's, of course, profound jurisprudence, there's also, I think, some assumptions about American society that we have, at least in theory, some of the same ideals and can operate in these tremendous freedoms in ways that allow our society to continue to exist and hopefully prosper. What I worry about today is not that we have continuing discussions and debates about precisely what the First Amendment means. We've had those for a long time. What I worry about is underneath some of those discussions are questions of the very legitimacy of the other side, that people no longer believe simply that you're wrong. That's okay. We've had that for a long time. But that you're wrong and that your views don't count, are illegitimate, not protected. And we see that not only in speech, but I think seeping over to religion and possibly some of the others. And to me, that's a very corrosive element of our democracy, which we'll undoubtedly go on to discuss. So I think the real issue, the real concern to me beyond the jurisprudence is, can we operate in this extraordinary level of freedom that the Bill of Rights has given us, but which assumes that we have some common ideals at a time when our society is increasingly polarized.
Okay. Thank you. And so, Anita, the question goes to you as well. First Amendment, why it's important, and what special First Amendment issues are of concern to you?
My response picks up on a couple of things that Jameel and Jeffrey have said. That's the benefit of going third. I can sort of leverage and benefit from what's been said before. Jameel mentioned the idea of a broad or broadly view of the First Amendment as intention with an alternative, such as constraints on the prerogative to speak. My view of the First Amendment is that it is not actually broad at all today, that it's suppressed, as interpreted by the courts, it suppresses and silences many groups of people in particular, and I take an interest in women, just based on my own experience, as a group of people who wish to speak and are not entirely permitted to do so in the current state of the law as it's used. And so that's my general kind of commitment to the First Amendment. I think that it's very important for individuals like me who have a particular interest to listen and reflect on what we hear on other takes or views of this very important source of American democracy. Now, when Jeffrey mentioned the absolute nature of the phrase, Congress shall make no law in the United States Constitution, that certainly is a very stark assertion about the freedom to speak. But as applied and as understood in the courts, there are lots and lots of constraints on what may be said. And I'm interested in particular in the non-controversial exceptions that courts in the Supreme Court in particular have long regarded as perfectly fine. So when we say that an individual may not make material false statements in a securities prospectus or cannot engage in defamation, that fighting words and obscenity also may be regulated, we've got a large number of limitations on the broad idea that people may say whatever they want. And so I'm interested in constraints and suppressions that are tolerated and even fostered, I think, by the current state of the law. As for the second question about today, I'll take a loose view of today and mention, as the other two panelists have, that digital media and the electronic nature of speech, I think we all agree, have made a big difference in what the First Amendment is doing today for a number of reasons. The permanent nature or quasi-permanent nature of electronic data means that speech is not casually forgotten and blown away after it's said. We're living in a self-publishing world, I think, where an individual's control of the social media space means that there's no barrier or filter, like a rejecting editor, to get in the way of the speaking and the possibility that someone else can hear it. And I think that this is an issue of interest to Jeffrey in particular. I think the sheer volume of speech has generated a different generational attitude toward freedom of speech, so that people who are younger than our median age or have a skepticism about freedom of speech that someone born in my year of birth wouldn't have. And I think that the idea of freedom of speech is evolving and changing as in a new demographic that has had a very different experience of what it means to hear words and say them.
Okay, thank you. Obviously, we are not going to be able to tackle the entirety of the First Amendment even in an hour. But instead, we're beginning to focus on those majestic words, the freedom of speech. But Jameel, I want to sort of pick up a little bit on what you had mentioned and what even some of the others had mentioned as well. And we were talking about this a little bit in the green room. When we talk about social media, the digital age, I don't think we can ignore a big development that just happened this week with the Federal Communications Commission. Could you tell us about net neutrality and why the decision made this week is an important one?
Sure. So yesterday, the Federal Communications Commission voted 3-2 to essentially end the requirement that companies that provide broadband service provide that service neutrally without reference to the content that they're carrying. So, the effect is, at least in theory, the companies that provide your access to the internet can now make decisions about can now discriminate on the basis of whose content they are carrying over their infrastructure. So in theory, an internet service provider could say, we're going to carry Fox's content very efficiently and carry MSNBC's not so efficiently at all, or vice versa, right? And there's very little competition amongst broadband providers, and so it's not a realistic option for somebody who is unhappy with their broadband service to go to another provider. They have monopoly power, and now they're going to have the power to use. They're going to be able to use that monopoly power to affect the marketplace of ideas. So I think that's a very dangerous thing, and I think it's unfortunate that the FCC has gone in that direction. But this actually relates to a larger question about gatekeepers, because ISPs aren't the only, internet service providers aren't the only gatekeepers. Facebook is a kind of gatekeeper too. Twitter's a kind of gatekeeper too. And these questions about the responsibilities of gatekeepers or platforms are immensely important questions for free speech right now. It goes back to what I was saying earlier. Do you want Facebook to think of itself as like the government in its commitment to basic First Amendment principles, including the principle of viewpoint neutrality? Or do we want Facebook to curate a community, to have the ability to curate a community? And it may curate that community with many different goals in mind. Some, all of them ultimately commercial goals, but some of them more about the identity of the company, about the kind of conversations they want to facilitate. But Facebook thinks of itself as a speaker or an editor or a publisher under the First Amendment for First Amendment purposes, although there are some important exceptions. But Facebook would claim First Amendment protection for its editorial decisions, its decisions about which content to privilege, what content to bury. Is that healthy for our democracy, or is it a threat to our democracy? And whether you conceive of Facebook as a gatekeeper or as a participant in the marketplace of ideas makes all the difference in the world to how you would answer those kinds of questions. I hope that wasn't too abstract. But
well, we're going to start connecting the dots in a minute, but I appreciate that. Obviously, we're talking about different forums in which speech occurs, different forums that are governed by different entities, some private, some public. And we're going to begin to see what overlap or disconnect there may be among those. To move from what seems to be disconnected, but I don't know that it is at all, the internet to campuses, Jeffrey. You talked about discourse perhaps being coarsened. And one area I think that's been of concern to you and certainly of concern to many other people has to do with campuses, universities, as places not just where speech occurs in all sorts of different ways, but where some speech, in fact, has been difficult. Some expression's been difficult. There's a lot of sensitivity on college campuses. How does freedom of speech work there?
I'll step back for a moment and we'll discuss throughout the panel the problems of free speech, gatekeepers and like, but I think the big picture is different, which is, the big picture is we have witnessed the greatest explosion of free expression in human history over the last few years. We had gatekeepers in the past. They were 3 network anchors in the United States and a couple of newspaper editors at premier newspapers. They were almost all white men in New York City. Today, a 17-year-old can have 10 million followers on YouTube without investing any money in advertising. So we are at an extraordinary moment, a revolution in communications that is without parallel. In any revolution, there are issues. And you cannot go as a society from one type of gatekeeper, the Walter Cronkite model, to something else, a couple of companies that didn't even exist 25 years ago, without a whole host of problems. And some of those problems, to focus now on the question you asked me, we certainly see on college campuses. Now, full disclosure, I was a college president of Colgate, so I have a vested interest in this. And I'll say that there are 4,000 colleges and universities in this country. And if you read a bad story any one day, it is a bad story. What's happened at Claremont or Middlebury or other places are bad. But with 4,000 campuses, I can tell you almost any story you want. Charles Murray does speak on all kinds of college campuses. Heather McDonald, who was booed off the stage of Claremont McKenna, does speak at all kinds of campuses. Even people from the alt-right do speak at all kinds of college campuses. So we have to be careful about focusing on incidents, bad as they may be. The real issue, which I think what you're correctly getting to, is polling data indicates that the current generation of young people have a different view of some First Amendment issues. They are profoundly committed to the First Amendment in theory, and freedom of speech ranks very high in their discussions. However, when it comes to some particular issues, particularly what's seen as derogatory messages directed towards women or minority groups, then many young people want to see a kind of carve-out of the First Amendment, that those statements, those expressions, and this is, I'm talking about a generation of millions of people here, so this is inchoate and imprecise, they are more prone than previous generations to want to see some kind of regulation of those particular messages in particular, directed at what they see as derogatory messages directed at minorities or women. And of course, this is all wrapped up now in social media because the horrible statement that was scrawled in the men's restroom in a previous generation of college may have been bad, but may have been seen by a couple dozen people. Today, anyone who tweets something out, it's seen instantly by the campus, potentially instantly by millions of people around the world. So the stakes are much, much higher. I think that we are going to have to face a reckoning with these different generational understandings of freedom of speech, especially as millennials become, they're already the biggest generation in our society as they become more politically powerful. And it all interacts with, as Jameel said, the social media issues and other issues. So I think it's an issue, but the speaker issue is a problem. I'd say it's overblown in many cases. The real issue is students' understanding of the First Amendment and their own views of what's acceptable speech.
Okay, thank you. Anita, I have a sense that you have a lot you're going to want to say here. Let me just ask you to work into your comments. A follow-up to some comments you had made. You talked about, if I heard you correctly, how to some extent women may not be able to express themselves or be heard as well, and I think, for example, on the internet or in social media. Did I hear you correct in that regard? And then secondly, so what can be done about that? What can be done about the hurtful silencing or the hurtful sort of constraint that may arise with regard to certain populations?
Again, I can benefit from what the other speakers have said. I do think you've characterized what I've said correctly enough.
Okay, fair enough.
I think that the problem for women as speakers in what's now a very crowded electronic world is that it's apparently acceptable to attack people, and them in particular, for their identity, to suggest that it's not that what she's saying is objectionable, but who she is. And to me, this is a very important source of silence. I know from my own experience, I've had ideas for blogs over the years. I've thought about starting them. And I just don't know, because I haven't actually had this happen to me, what it would be like to turn on the computer every morning and find that I am attacked in what I would expect it to be a crude way, and to make it respectable and baseline rather than shocking, to suggest that I need to suffer some kind of sexual penalty for my transgression. So I haven't written a blog yet, and I'm a little leery, even in the modest way that I've contributed to online discourse, to speak that way. And I have to magnify and multiply my experience by the thousands that must be present out there. So when I was listening to Jameel talk about net neutrality, I think we've got a kind of parallel here. I'm sure that the head of the FCC thinks that he's bringing the freedom. He's allowing businesses to step up and do what they wish, and if and they are vulnerable to the forces of the market and their shareholders, and they won't be able to get away with control unless their constituents are happy with them. And I think he would not agree that his move on net neutrality was a negative or a problem for freedom. And so I guess I'd be disagreeing with you, Jeffrey, to say that the young person sentiment that you've summarized is a carve-out to freedom of speech. I think rather it's an expression of worry that the playing field isn't fair and level, that some fraction of the speakers who want to get in there are being disadvantaged before they even open their mouths or turn the on button on their phones. And so what may be necessary is an awareness of the injustices that are structural and attack individuals for who they are rather than for what they're saying. That when you ask Michael, what can be done, I think given the profuse exceptions to absolute expression that we already have, it might be possible to identify attacks on a person's identity as not consistent with freedom of speech. What I have in mind is a kind of revival of the old semi-discredited idea of fighting words. And I haven't read the Chaplinsky case since I was in law school, which is not yesterday. I keep adverting to my age. And I've literally had not looked at that case in decades. And it's kind of silly, and I guess it's dwindling. You'd know better than I. It's shaky fate in the courts. But in Chaplinsky, the speaker was in Rochester, New Hampshire, proselytizing, and he called his interlocutors goddamn. He denied the goddamn, but fascists and he called them these summary names that the Supreme Court apparently unanimously agreed would cause any reasonable person to want to start disturbing the peace. So not all of us get the benefit of fighting words. African American men are not permitted pretty much to engage in condoned violence. And I know growing up I was never taught that any provocation of any kind would be sufficient to justify my swinging a fist or resorting to physical aggression. So I think not all of us got the benefit of fighting words as something that was regarded as legitimate and proper in response to a provocation. But the idea has some soundness, I think, that some summaries of a person, maybe fascist back in 1942, are so silencing, so preemptive, so comprehensively hostile that they result in a problem that's worth worrying about. And so I'd be open to some constraint on speech that focuses on attacks on a person's identity that say to her, you are not permitted to participate in the discourse. If those responses to her are powerful enough and meaningful enough, I think the state, or I don't go so far in my writings to actually recommend legislation, but that it becomes proper to say that's not okay. And what you're doing in attacking the identity of another person is not constitutive of a robust discourse.
Okay, and Jameel, you should certainly feel free to respond to any part of that. I'm going to try and ask you a one-part question, though, if I may. And I hope it's a fair question. But I'm going to try and sort of link together some of the comments that have been made, including yours. I for years, had a wonderful colleague who, the First Amendment scholar, his name is Rod Smola. You may know Rod's work. And one of the theories that Rod put forward was that there really was not just one First Amendment. There was a First Amendment for different areas. There's a First Amendment in schools, First Amendment in prisons, and so on. Would you agree that with that idea that maybe there's a First Amendment that applies to the internet, but not necessarily to in-person exchanges on a campus?
I don't know, but even before you asked the question, I was going to make a comment that's related. So let me make my related comment and buy some time on your question. I think many of the most difficult and most interesting questions right now relating to free speech involve conflicts not between free speech and some other value like equality or privacy, but conflicts within free speech, a contest over the meaning of free speech. And in those kinds of contests, free speech doesn't win or lose. It both wins and loses. But a particular vision of free speech wins and a particular vision of free speech loses. And often the conflict lines up with conflicts between speakers and listeners, right? So I keep going back to the same examples, but with Facebook, Facebook might, in certain contexts, conceive of itself as a speaker, or an editor making editorial decisions. But its users are also exercising free speech rights, right? Whether they're recognized by the First Amendment or not is a different question, but they're engaged in free speech. And a vision of the First Amendment that privileges Facebook's editorial decisions, that gives protection to Facebook's editorial decisions, may be a vision of free speech that deprioritizes or subordinates the interests of the participants on Facebook's platform, right? So this, I think, is related to what Anita was saying earlier. Some of the decisions that the social media platforms make may be protected by the First Amendment, but the result of those decisions might be, in some contexts, to chill the speech of people who might otherwise participate in their platforms. A lot of people criticize Twitter for not having dealt with the abuse or harassment problem on Twitter, making it too easy for trolls to attack women or other minorities based on their status rather than the arguments they make. And Twitter might say, well, our editorial decisions are, we are cultivating the kind of community we want, and that reflects decisions that are protected by the First Amendment. We are speakers or editors. We are First Amendment actors. And you could accept that vision of the First Amendment, but you should recognize that accepting that vision of the First Amendment has the effect of privileging one set of speakers, the social media platforms, and arguably subordinating the free speech rights of people who use those platforms. So, again, I'm not offering answers to any of these questions largely because I don't have them, but I think those are really important questions, and you see this over and over again in a lot of different contexts. I think Anita's right. The internet service providers will say the decision yesterday is a decision that actually increases First Amendment freedom because it gives us, the internet service providers, the authority to make some decisions that we previously couldn't make, editorial decisions or quasi-editorial decisions that we previously couldn't make. And that may be true, but there's a cost to that, and the cost is also a free speech. The benefit may be a free speech benefit, but the cost is a free speech cost.
So we are, if you don't realize it, we're going really deep here. And I want to sort of at least identify a few of the different moving parts. So one thing obviously we've been talking about is the internet. To some extent, it's privately managed. And then there are questions about the extent to which the First Amendment would apply to that or not. That's going to lead me to my question to Jeffrey, which is, given your experience with education, is it your sense that a private university deals with speech differently than a public university? The Constitution applies to public institutions. And so if you're at the University of North Carolina like I am, the First Amendment applies there because it's a state actor. But it doesn't apply to Colgate, which is a private university. How does speech differ then on those different campuses, or does it?
It doesn't really. I don't know the president of a single private university who would say, on my campus, we have fewer First Amendment rights than in a public university.
Well, they wouldn't put it that way.
No, not only wouldn't they put it that way, though, they're not going to act that way, except for one specific set of issues, which is I think that private universities have the ambition to have all of the First Amendment rights of free expression, except that private universities are not under some strictures to allow speakers to present whether they've invited them or not. Not whether they endorse them. Many people speak at public universities without the endorsement of public universities. But we've seen recently the Richard Spencer and some other issues where people have taken advantage of the public nature of some campuses at Florida and Texas and elsewhere to essentially say, I am entitled to speak there. You couldn't say that at Colgate. But that's people using the public campuses in a particular type of way. It's not the administrators of private campuses saying it. I will say that, continue on looking at students, there has been a shift, and I think it's a profound one, in how people who critique our society for very good reasons about inequality view First Amendment freedoms. A generation ago, maybe 2 generations, depending on how you're counting, Martin Luther King and his colleagues used all 5 freedoms of the First Amendment to advance their arguments for equality in American society. And in fact, King's last address in Memphis a few days before he was killed, the "I've been to the mountaintop" speech, was a ringing endorsement of freedom of speech and the other First Amendment freedoms. We've seen that flip now in the last 50 years, where in some of the subgroups that are most skeptical of freedom of speech in particular are African Americans, women in some cases, and others who rightly see profound inequalities, but no longer see First Amendment freedoms as the avenue for advancement. I think that tactically, we can discuss the jurisprudence separately, tactically what we've seen is that King was right, I think, that the First Amendment is the vehicle for advancement of equality arguments, and that restrictions, at least on campuses, I won't go further, restrictions on speech tend almost inevitably to rebound on those minority, and in many cases women groups, who thought the restrictions would protect them in the first instance, but they end up restricting them more than anyone else. And I think that's one of the reasons why free speech codes on campuses have been counterproductive.
Okay, thank you. Anita, I want to give you a chance. I have a feeling you might want to respond to things that both Jeffrey and Jameel have said. So I won't ask the question. I'll see if you have a response or comments.
I feel that you won't take the First Amendment out of my cold, dead hands. I really love it. I feel that I'm kind of carrying this flag that Owen Fiss published 20 years ago. He called it The Irony of Free Speech. I think that without some awareness of who is getting to speak and who isn't, we don't really have a meaningful freedom at all. And I think it's infinitely important to worry, as many of others, not myself or myself included, have done, about what are we not hearing. I can't imagine the quantity of discourse that I simply do not get because individual speakers can't get in. They know, and I'm thinking about beyond women, members of minorities who report similar, though I guess different experiences to some degree as well. Look at, say, the comments pages of most media sites. I think 9 out of 10 are horrific, and decent people won't go there. I'm fond of The Nation magazine, and they've got a tiny single-digit number of commentators, but Jameel's published in there last year. I've been blocked because I won't pay for to support them. I think they're kind of Putin enablers. So I only have 6 articles a month, and I wasn't able to download. I had to get someone else to do it. But when I read the comments in the margins, it just seems just a pustule of misogyny, such that I know that other people are not there. I'd like to be a nation. I'd like to be a subscriber and commentator. And so I think it's not a tension between freedom of speech and something else, but rather a very difficult struggle to figure out how to get the realm open so that the small fraction of voices that we're hearing don't occupy the entire field. And so I very fervently believe in freedom of speech, and I hope I'm not being received as someone who is against it.
No, I don't think so. I want to come to Jameel and talk a little more openly about hate speech. We've sort of everybody's touched on it in one way or another, and it's obviously a theme to some extent of what we're talking about today. And this will be, unfortunately, probably more than one part, but it really is just designed to sort of ask you: is there a concept out there called hate speech, and to what extent is it regulable?
Mm-hmm. Well, for better or worse, right now the First Amendment is interpreted broadly in this particular respect. It protects even what most people would colloquially call hate speech. There has been, over the last 50 years, a debate about whether that's a good thing. There's this article that I recently had occasion to reread that Charles Lawrence wrote 30 years ago, arguing that the First Amendment, and Charles Lawrence is somebody who's very committed to foundational First Amendment principles, but he is an African American who grew up in the South and knows the connection between the words and a system of profound discrimination. And he argues that the First Amendment should be interpreted to exclude face-to-face insults, face-to-face racial insults. And I actually read that article, I went into that article expecting to disagree with him, but I came out of it thinking, first, he makes a very good argument that these kinds of insults aren't a contribution to a discussion that, to any discussion that we actually want to have, and also that an exception to the First Amendment or construing the First Amendment slightly more narrowly in this particular respect would not be as unmanageable as I at least thought it might be. So I'm actually more open to this than I was even 18 months ago. But to me, one of the hardest questions here isn't so much about how to interpret the First Amendment, whether the First Amendment should be interpreted to protect this kind of speech, but to what extent those of us who advocate for a broad vision of the First Amendment should feel obliged to use our resources to support those speakers who engage in that kind of speech. And I don't want to go on for a long time, but very briefly, I was at the ACLU for 14 years before I took my current job. The ACLU is famous most of all for its defense of neo-Nazis who wanted to speak in Skokie, Illinois, and there's a debate within the ACLU right now about should the ACLU use its resources to represent neo-Nazis who want to demonstrate in places like Charlottesville. And even if you accept that the First Amendment should be construed very broadly, I think it's a hard question to what extent organizations that think of themselves as First Amendment organizations have an obligation to represent those hateful speakers. And it's a different question from the question of what the First Amendment protects.
Our overarching concern at this point is to some extent trying to figure out where the boundary is on expression. Jeffrey, I want to ask you a question that just comes straight from the audience, if it's okay. And this also kind of picks up on one of the other ways in which expression may manifest itself. So how do you think conflicts between freedom of speech, such as the Baker and the Colorado case, and the right not to be discriminated against, such as the gay couple wanting a cake, should be handled? So clearly there's a tension there. Does the Baker have a right of expression there? Is that what's at stake in this case?
It's an important case, and I think we should all follow it. My own view is that in this case, there's no justification for discrimination. That I don't see the Baker as a cake artist whose freedom of speech is being constrained. I think the court would do well, I think it will find that way. I think the court would do well by us, however, to start to establish some lines, because there clearly are some lines, not in the Baker case, I think, but where people's speech can be protected even if it is seen as discriminatory. I don't think that's this case. But I think the court would do well to provide us with more guidance. I'd also say, I know I'm in the midst of lawyers in a constitutional center, that freedom of speech and making legal use of hate speech or making it illegal is not the only issue. There's also an issue of politeness and etiquette in our society, which we seem to have lost. I agree with you completely on the comments. I don't think the government has any business regulating the comments section of newspapers, but I think we should ask, and I think Jameel makes a good point, that if you are a First Amendment advocate, you better be really concerned about the content of what you say you're protecting. And I think the comment sections are profoundly embarrassing. And we should ask ourselves, what happened to any notion of etiquette or politeness? Forget about the government's role for a second. And I think that in many of our issues, we have lost that sensibility. That it's not only a question of whether something's legal or not, but what happened to our mutual responsibilities to each other as citizens in society. And I think bringing back a sense of politeness and etiquette is also important. And I think because I take it that as a First Amendment advocate, I'm in favor of people saying a lot of things which others find objectionable, but these issues of etiquette and politeness are especially important.
They're very important, though of course they raise the challenge of trying to figure out the boundary again. How far can you go? So Anita, one other question from the audience is about bullying. We can assume, and probably all presume, that bullying in faith, when we're together, in personal interaction, can't and shouldn't be done, and it's not protected by the First Amendment. But what about bullying on the internet? When it doesn't call for violence, can that be stopped, and is that covered by free speech?
That is a very difficult problem to regulate, and I don't have a terrific fix, but it just builds on what was said, so I think it might be timely, if not necessarily useful. The challenge of improving the discourse, making it more polite and civil, and at least with some kind of default of respect, I think it could be helpful here. About 3 years ago, I published a law review article, and its title was Abuse and Harassment Diminish Free Speech. My idea in that was to think about the major online platforms. At the time, they were Facebook and Twitter, but we could just fast forward a little bit to Instagram, and even, I'm told, YouTube. I thought that sentence could be a kind of pledge that I would invite these private corporations to embrace if they chose, and that would help with the bullying problem that the audience member has raised. If this content provider or platform would say, we agree that abuse and harassment diminish free speech, then that doesn't necessarily provide an action item for them to squelch or censor anyone in particular, but it would be an invitation for the volunteers, the people who step up to comment, to reflect on that, and if they disagree, they can express the problem they have with that idea, but at least we would delay or forestall some of the attacks that might just shoot out spontaneously. And once we can have an approximate fragile consensus, and I know the word fragile consensus is kind of a tautology, like dysfunctional family, that's one of my friends says. So the consensus will be fragile, but I think if we can agree that abuse is not only troublesome for other reasons, but that it actually suppresses speech, so that it defeats the very point of the construction of a place to speak, then we have a way to perceive bullying as a problem and focus on it with particular solutions depending on what exactly the bully did.
Right. I feel also compelled to some extent to bring up another issue, Jameel, just because we want to touch on everything in the area of freedom of speech if we can. We've talked about, obviously, the internet, talked about social media, talked about bullying, talked about other ways in which speech might go too far, also talked about protections, but we haven't talked about money, and to what extent money is related to speech. Obviously, that's important because we've just had a significant election in Alabama. We have other elections coming up, and all of those turn on, one way or another, money that comes into campaigns and helps fund speech. Citizens United, of course, is the big Supreme Court decision that recognized protection for corporations and using money as a way to support their speech or expand their speech. do you see any negative effects from that? And if so, how can they be contained?
Yes.
A leading question.
Yeah, so I think of this as one instance of the sort of speaker-listener distinction I was referencing earlier. So the Supreme Court for many years, at least since the 1980s, has cared almost entirely about speakers. And, it's a right to free speech, so there's, an obvious logic to focusing on speakers. But I think we would be better off with a First Amendment that cared more about listeners and about the integrity of public debate, about the vitality of public debate. And if you brought that kind of frame to questions like campaign finance or commercial speech or regulation of social media or the public's right of access to information in government custody. A First Amendment that was more concerned about protecting listeners and protecting the vitality of public debate, not necessarily at the expense of speakers, but, a kind of complement, as a complement to the court's solicitousness to speakers, I think we would have a healthier democracy. That's not that doesn't have the specificity of a doctrinal, recommendation, but I think changing the frame we bring to some of these questions would be a good thing.
Well, I wanted to see if we can touch on at least some of the different issues I think that would be of interest to a wide range of people. Jeffrey, I'm going to come to you with a question, then to Anita, and then we're going to do a kind of a brief wrap-up for all of you. I want to come back, if you don't mind, to the university setting and ask the basic question, whether or not university itself has a right to speak. Does it have any protected interest in expression?
Universities do speak. As a college president, I spoke. I filed a friend of the court brief on one of the affirmative action cases. I thought it was appropriate as a college president to speak on an issue that was directly related to higher education and that would affect my campus. Universities have the rights in the person of the president to speak on any issue they want. Whether it's wise to is a completely separate issue. I thought it would be inappropriate for me to invoke the university's prestige or whatever to discuss issues which were not related to higher education and which did not affect our campus because that was bringing the institution a vulnerability which I didn't like, and I thought would distort discussion on campus about those issues when I wanted those issues, whether they be nuclear weapons or regulation of tobacco or American foreign policy, to proceed without the president saying anything about them. So I think campuses should speak, but I think they should speak about issues that affect them and presumably that they have some expertise about. I wouldn't mind taking a whack at Citizens United.
Sure. Sure. Do you want to rephrase that?
Hey, Citizens United was about a movie about Hillary Clinton. So, and whether that movie could be banned or not. And remember, the government took the position that movies and books could be banned. I mean, it's often posed as, could you regulate money in campaigns? But it got to pretty basic issues pretty quickly. I would take a slightly different point that money is so determinative of elections. If that was the case, Hillary Clinton would be president right now. I have a real worry that when people talk about Citizens United, they're talking about it would have to be an amendment, I think, to the First Amendment in a way that we should at least slow down and think about all the different implications. Because if one thing we've learned about speech is that regulating someone's speech produces all kinds of unexpected consequences that often rebound on the very people we're seeking to protect. So I would be careful.
I want to give Anita a chance to respond to that first.
I have a remark on Citizens United as well, which is that it's called by that name, those two words, but that's the short form of the actual corporate name that these people who were participating in the American electoral system had formed for themselves. It's short for Citizens United, Not Timid, and it's meant to be an acronym aimed at Hillary Clinton. It's as misogynist a company name as one could possibly think of. It was directed at a particular individual, and it addressed her as someone who, because she is a Citizens United, Not Timid acronym, is an illegitimate holder of power. So I think that when you bring up Citizens United, you've actually intersected with my interest in misogyny and misogynist suppression of speech that I think is such an important problem on the internet. I too, I guess, like everyone else on this panel, am very disheartened by the way the Supreme Court came out on this one. And I think just to relate the outcome of that case to what I and others here have been talking about, the role of money in speech, I think it kind of mirrors or parallels the role of dominant speakers who don't want to hear what they don't want to hear, suppress it and silence it. Just as big bucks can do that in campaigns, so too can power holders function to put a jackboot on the throats of speakers who have less power than they.
Okay, thank you. So we are almost out of time. If I were to ask a last question, it might even be just a way to have us think about whether the Supreme Court has erred on the side of allowing too much speech to go, in a sense, unchecked. But I want to give each of you at least a couple minutes to sort of offer your final thoughts as well on particularly freedom of speech. We can't end our discussion here on Bill of Rights Day and focusing on First Amendment without sort of thinking about what do you want the takeaway to be on the audience's understanding, knowledge of the First Amendment.
Am I first? All right. So I guess I think the most important thing to recognize is that the First Amendment, as we've inherited it, was developed mainly in the 1960s and 70s. The cases that we would all name first as the court's big First Amendment hits are from that era, and that was obviously before the internet, before smartphones, before pervasive surveillance, before WikiLeaks. And there's a real question about whether that framework is adequate to the challenges that confront us today. I think Jeffrey said this earlier, but or at least alluded to it earlier. But the model we have is based on the idea that the main threat to free speech comes from the government, and that the threat takes the form of censorship. And now often what we conceive of as threats to free speech actually come from private actors, not from the government. And the threat doesn't always take the form of censorship narrowly understood. Sometimes it's quite the opposite. It's flooding a space with too much information or false information, or it's harassment. And these have the effect of silencing, just as direct censorship does. But there are new forms of silencing. And so, I think it's, I think I've said now 3 or 4 times that I don't have answers to these questions. But I do know that these questions are urgent, and my sense is that the framework we've inherited needs to be reconsidered fundamentally for an age in which the technologies of communication are so different.
Okay, thank you. So Jeffrey?
One thing we haven't talked about, but I think important to mention on this day, in terms of threats to the First Amendment, the most immediate one is we're much closer to amendment on flag desecration than many people believe. And that is an issue that should be watched very carefully, because a great number of states have already committed to endorsing an amendment prohibiting flag desecration. And if the national politics were to go a certain way, we might see that very quickly. That's not on a lot of people's agenda, but it's actually the biggest formal threat to the First Amendment. I think we all recognize that we're in the middle of a revolution. Actually, we're in the first days of a revolution. How we communicate with each other, how we get information, how we portray ourselves has been radically changed in just a few years by our devices. Not surprisingly, as Jameel said, a lot of things therefore are up for grabs, which we hadn't either thought about or weren't issues in the past. And I think we are going to have to address these issues forthrightly as a society. I think we've all been correctly humble in proposing solutions because the world has changed so quickly in such a short period of time, and we know those changes are not over yet. But I think we need to devote real attention to the issues in a more forthright way than we're used to in our society these days, because they're going to come up. To just take one issue, I was asked when I was in Washington every couple of months by Congress, hey, would you support us on a congressional initiative to look at issues of encryption and privacy that are, of course, very important, especially after the San Bernardino cell phone case with Apple and the FBI. I said, sure, I'd help you, and I'd bring the organization I led resources to help you also, and then nothing would come of it. Month after month, when Congress said, we need to address this issue, but we don't know how. And we never got any further. And when I talked to the FBI, I've talked to the director, I've talked to the general counsel in public, they say, we shouldn't be making law. We should be following the law, but the law's not there at the moment. And I think we celebrate the revolutionary effects of these devices and their potential without paying enough attention to how our society is going to advance with them.
Okay. Thank you. Anita.
Jameel said something interesting that I wanted to underscore because I think it makes a nice wrap-up. I guess I'll be the last of the speakers. As you remember, he adverted to the importance of listeners and a wider community that participates in discourse. And I think that that's a concern that needs to be highlighted. It's extremely important, and yet I want to also, because we're plenary and we're large and we contain multitudes, I think that's the idea here. Remember the speaker as well, especially if we are hearing from all the speakers who have something to say. The First Amendment needs to be, as applied, I mean, as it really is, it needs to be mindful of the sectors that benefit from the freedom to engage in expression and to reflect on something unfamiliar that we haven't thought of ourselves, that's external to us, and challenges our foundations in a way that we can hear it. So I thought that we had a really good coda in that observation of Jameel's.
Okay, thank you. It has been an incredible honor to be here on Bill of Rights Day with everybody, and particularly here with all of you to have a terrific, nuanced discussion about freedom of speech, which I am sure will extend beyond today into our next celebration of Bill of Rights Day. I hope we've all agreed we've learned a lot today. Thank you.